What if the biggest royal scandal of the decade isn't the interviews, the Netflix cameras, or even the tell-all memoir, but something far more fundamental? What if the real question isn't about hurt feelings or fractured relationships, but about bloodlines, law, and a centuries-old rule that no one dares to say out loud? And what if the silence surrounding it is louder than any accusation ever could be? For years, the public narrative around Prince Harry and Meghan Markle has revolved around culture clashes, press intrusion, palace politics, and emotional betrayal. But beneath the glossy interviews and carefully curated statements, another story has quietly simmered, one that touches the very core of the British monarchy's legitimacy. It is a story about birth, about succession, and about a phrase so old it predates modern democracy: born of the body. For words that have determined kings and queens. For words that now hover, uncomfortably, over Montecito. There is a growing sense among royal watchers that something doesn't add up. Not because of internet conspiracy theories, not because of tabloid exaggeration, but because of the gaps, the missing pieces where clarity should have been automatic. In a family where every royal birth has historically been documented with near-ceremonial precision, why did these particular births unfold in such an unprecedented way? Why did tradition, which had survived wars, abdications, divorces, and scandals, suddenly become optional? Let's be clear, the British monarchy is not a celebrity brand. It is a constitutional institution. Its power and survival rest not on popularity alone, but on legal continuity. The line of succession is not symbolic, it is law. It is embedded in documents like the Act of Settlement of 1701 and reinforced by centuries of precedent. The legitimacy of an heir has always required clarity, not ambiguity. And this is where the tension begins. When Archie Harrison Mountbatten-Windsor was born in May 2019, the announcement broke from tradition in ways that startled even seasoned royal correspondents. No immediate photo call on the hospital steps. No formal medical bulletin signed by attending physicians displayed on an easel outside Buckingham Palace. No public confirmation of the labor timeline before the birth occurred. Instead, there was a delayed announcement. There were inconsistencies about when Meghan went into labor. There were reports that the palace press office confirmed the birth after it had already happened. In isolation, each of these deviations could be dismissed as modernization. A younger couple choosing privacy. A departure from outdated customs. But in the context of constitutional monarchy, privacy collides with protocol. Royal births are not public spectacles for entertainment. They are public confirmations for legitimacy. Prince Harry later described the birth in his memoir Spare with intimate, almost cinematic detail. Electric candles, soft music, a deeply personal atmosphere. He wrote about being present in ways that previous generations might not have been. It was touching, human, emotional. But the memoir also emphasized how quickly they left the hospital, how private and insulated the experience was. For some readers, it was beautiful. For others, it raised questions about process. Then came the birth of Lilibet Diana in June 2021 in California. Harry described delivering his daughter himself, recounting the moment with tenderness and pride. Again, no one disputes a father's desire to be involved. But the context matters. These children are not simply private citizens. They sit in the line of succession to the British throne. And in a monarchy governed by inherited legitimacy, documentation has never been optional. The phrase "born of the body" has quietly defined eligibility for succession for centuries. It exists not as gossip, not as rumor, but as legal language embedded in the framework of hereditary inheritance. The question that now circulates in certain corners of public discourse is not about morality or modern family structures. It is about legal definition. This debate intensified recently because of an unrelated but legally significant aristocratic case involving the Marquess of Bath. In open court, the issue of surrogacy and inheritance collided. A child born through surrogacy, biologically connected to the family, faced legal uncertainty regarding eligibility for inheritance under the specific wording of long-standing trust documents. The judge acknowledged ambiguity. The law did not automatically adapt to modern reproductive methods. That case did not involve the royal family. It was not about Harry or Meghan, but it exposed something crucial. British inheritance law and aristocratic succession are still shaped by language that predates assisted reproductive technology. In private estates, such issues can be resolved through petitions and legal adjustments. In the monarchy, the framework is far more rigid because it intersects with constitutional law. And that is where the discomfort lies. If a noble title or estate can face uncertainty under born-of-the-body language, what about the line of succession to the crown itself? The monarchy cannot quietly amend foundational principles without parliamentary involvement. It cannot operate on ambiguity. Its authority depends on clarity. To be absolutely fair, there's been no official confirmation that surrogacy was involved in either Sussex birth. There is no publicly verified evidence to support that claim. It remains speculation. But the persistence of the speculation is the real story, because speculation thrives in silence. Why hasn't there been a straightforward, definitive clarification addressing these questions once and for all? Not legal threats, not media management, just a simple constitutional confirmation that all requirements for succession have been satisfied under existing law. For critics, the absence of such clarity fuels suspicion. For supporters, the demand for proof feels intrusive and cruel. But the monarchy does not operate on feelings. It operates on law. Prince William's position in all of this is uniquely complicated. As the future king, he will inherit not only the crown but any unresolved institutional vulnerabilities. If there are questions, however unfair or unfounded, about succession legitimacy, they do not simply disappear. They linger. They resurface. They erode trust. William has consistently demonstrated a desire to modernize the monarchy while preserving its structural integrity. He understands that public confidence is fragile. He knows that scandals can be weathered, but constitutional uncertainty is far more dangerous. It is one thing for a royal to give an explosive interview. It is another for the rules of succession to be clouded by unanswered questions. Meghan's critics often point to her silence as strategic. They argue that legal letters and reputational management have replaced transparency. They suggest that the Sussex brand benefits from ambiguity because it keeps attention alive. But silence can cut both ways. It can be read as dignity or as avoidance. The palace's own handling of the births added to the perception of irregularity. There were corrections to birth certificates. There were shifts in announced details. None of it necessarily implies wrongdoing. Administrative adjustments happen, but in a monarchy where even minor changes attract scrutiny, optics matter. Some argue that the institution itself chose flexibility to avoid conflict. Others believe the palace wanted to protect privacy at all costs. But protecting privacy and protecting constitutional certainty are not the same thing. The monarchy has survived abdication crises, wars, divorces, and even the death of a beloved princess. It has endured public outrage and internal rebellion, but it has never survived a legitimate challenge to the validity of its heirs. That is the red line. And this is why the broader aristocratic court case struck such a nerve. It was not about gossip blogs. It was about legal precedent. It demonstrated that under certain interpretations of long-standing language, surrogate-born children may require explicit legal recognition to inherit under traditional terms. If Parliament ever had to address that issue in relation to the crown, the implications would be seismic. Not because modern society rejects surrogacy, far from it, but because constitutional law moves slowly, deliberately, and publicly. It cannot rely on personal narratives. It requires formal alignment. The deeper issue here is not whether Meghan or Harry have something to hide. It is whether the monarchy can afford lingering doubt. Doubt is corrosive. It invites political actors, legal activists, and anti-monarchists to probe vulnerabilities. In a republic, questions about birth certificates are administrative. In a hereditary monarchy, they are existential. Harry and Meghan have framed their departure from royal duties as a step toward independence and authenticity. They have criticized institutional rigidity. They have spoken openly about feeling unsupported. But independence from royal duties does not automatically sever succession status. Titles and positions remain intertwined with the constitutional structure. Critics argue that you cannot reject the institution while retaining its privileges. Supporters counter that they are entitled to both personal freedom and inherited status. That tension has defined the Sussex narrative since 2020. Yet beneath the emotional headlines lies the cold reality of legal language. Born of the body does not adapt itself. It does not modernize spontaneously. It sits in historical documents, unchanged unless formally revised. If there is nothing to question, clarity would strengthen everyone involved. It would protect the children from unfair speculation. It would shield the monarchy from destabilizing rumors. It would close the chapter. But until clarity arrives, the conversation persists. Some royal commentators believe William will prioritize institutional stability above all else. They speculate that any ambiguity, real or perceived, will eventually require formal resolution. Others argue that raising the issue publicly would create more damage than silence ever could. And so the tension remains suspended. The Sussex children are innocent in all of this. They did not choose their roles. They did not choose public scrutiny. They deserve privacy and dignity. But constitutional frameworks do not operate on sentiment. They operate on verification. The public's fascination with this topic is not purely malicious. It reflects a deeper anxiety about transparency in modern institutions. Trust has become fragile in the digital age. When information is withheld, people fill the gaps. The monarchy, perhaps more than any other institution, depends on ritualized transparency to maintain legitimacy. Coronations are public. Weddings are public. Funerals are public. Births have historically been public in form, if not in intimate detail. When tradition is broken, explanation becomes essential. Prince William faces a future in which the monarchy must adapt without unraveling. He understands that optics shape perception. He also understands that constitutional law cannot be rewritten by press release. If Parliament were ever forced to examine succession eligibility in light of modern reproductive technology, it would not be a personal attack. It would be a structural recalibration. But the mere possibility of such examination introduces instability. And instability is the one thing the monarchy cannot afford. Perhaps there is no grand secret. Perhaps there was simply a modern couple prioritizing privacy. Perhaps palace officials misjudged how deviation from precedent would be interpreted. Perhaps legal compliance was satisfied quietly behind closed doors. But in the absence of public confirmation, speculation thrives. The story has evolved beyond tabloid drama. It now sits at the intersection of family conflict, legal precedent, and constitutional identity. That is why it refuses to disappear. Every time a related legal case surfaces, like the Marquess of Bath's inheritance dispute, the spotlight shifts back to the Sussex situation. Not because the cases are identical, but because they illuminate the same legal language. For a 1,000-year-old institution, language is destiny. If everything aligns with constitutional requirements, then a clear affirmation would silence critics overnight. If adjustments are needed to modernize succession law, then Parliament could address them openly. Democracies adapt. What cannot endure is ambiguity. In the end, this is not a story about personal animosity. It is not about liking or disliking Meghan. It is not about choosing sides between brothers. It is about whether the rules that define hereditary monarchy remain intact in a modern world. Prince William did not create the questions. He inherited them. And as future king, he may eventually have to ensure that the answers are as solid as the crown itself. Because a monarchy can survive scandal. It can survive controversy. It can survive public criticism. But it cannot survive uncertainty about its own foundation. And until that uncertainty is definitively addressed, one way or the other, the whispers will continue. And here's where the tension deepens, because the longer this question lingers in the public consciousness, the more it transforms from gossip into something heavier, something institutional. Time doesn't bury uncertainty in a constitutional monarchy. It amplifies it. Think about how the royal family has historically handled even the smallest matters of protocol. The color of an outfit at a state event can generate days of analysis. The positioning of a family member on a balcony can spark weeks of speculation. This is an institution that understands symbolism at a microscopic level. So when something as significant as the birth of children in the line of succession departs from centuries of precedent, people don't just shrug and move on. They study it, they compare it, they replay it, and they ask why. When Prince George was born, the world knew exactly where Catherine was admitted. There were official bulletins. There were photographers waiting in a clearly designated area. The moment the couple stepped onto the hospital steps, it wasn't about celebrity. It was about continuity. It was about reassuring a nation that the line of succession remained secure and visible. That visibility has always served a purpose. It protects the monarchy from rumor. It prevents conspiracy. It creates a shared, documented reality. Contrast that with the Sussex births. Announcements that seemed delayed. Confusion over timing. Corrections to official communications. The absence of the traditional medical bulletin signed by attending doctors. Again, none of this automatically implies wrongdoing. But in a system built on ritual clarity, deviation demands explanation. And explanation never fully came. Instead, what followed were waves of defensiveness. Legal letters reportedly sent to media outlets. Strongly worded responses to what were framed as intrusive or malicious questions. But legal pressure does not replace constitutional reassurance. In fact, for some observers, it had the opposite effect. It suggested that even asking the question was forbidden. In modern public life, especially in the digital era, attempts to suppress questions often make them louder. There's also the psychological dimension. Meghan and Harry position themselves as champions of transparency, authenticity, and truth. They criticized palace secrecy. They condemned institutional opacity. So when critics perceive opacity around their own circumstances, they interpret it as hypocrisy. That perception, fair or unfair, is politically potent. Now layer on the broader context. The monarchy is already navigating delicate territory. King Charles faces the ongoing shadow of past scandals within the family. Public support for the monarchy fluctuates, especially among younger generations. Republican movements quietly gain traction during moments of controversy. In that climate, even minor uncertainties can be weaponized by critics who question the relevance of hereditary rule in the 21st century. Prince William is acutely aware of this environment. His approach has often been described as cautious, strategic, long-term. He has seen what unchecked scandal can do. He witnessed the damage from the breakdown of his parents' marriage. He experienced the media storm around his mother's death. He understands that perception can destabilize even the strongest institutions. So if there are whispers that could one day escalate into formal challenges, it would not be surprising if he views them as potential risks to neutralize, not through aggression, but through structural clarity. That does not mean secret investigations or dramatic showdowns. It could mean something far quieter. Legal review, consultation with constitutional experts, contingency planning. Monarchies think in decades, not news cycles. One of the most uncomfortable aspects of this entire conversation is that it involves children. Archie and Lilibet are young, innocent, and unaware of the political weight attached to their names. They deserve protection. They deserve normalcy, to the extent possible. Yet the paradox of royal birth is that personal life intersects with public consequence. The monarchy has always balanced that tension imperfectly. Children are shielded, but their existence carries national implications. If surrogacy were ever formally acknowledged in relation to succession, it would not necessarily disqualify anyone automatically. Modern law can evolve. Parliament could amend relevant statutes. But the process would be public. It would require debate. It would force the monarchy to confront whether ancient phrasing still governs modern realities. And that debate would not be quiet. Consider how contentious even minor changes to succession laws have been historically. The Succession to the Crown Act 2013, which ended male preference primogeniture, required agreement across multiple Commonwealth realms. Adjusting constitutional language is not simple. It involves diplomacy, legislation, and consensus. So if ambiguity exists, the cost of resolving it grows over time. there is also the international dimension. The British monarch is not just head of state for the United Kingdom, but for several Commonwealth nations. Succession questions ripple beyond British borders. They affect political relationships and symbolic unity across continents. That is why clarity matters so profoundly. Another layer to this is public trust. Trust in institutions has eroded globally over the past decade. Governments, media organizations, corporations, none are immune. The monarchy survives largely because it is perceived as stable, predictable, above political chaos. If it appears evasive or inconsistent, that perception weakens. Harry and Meghan have argued that the institution failed them, that it prioritized image over humanity. Their supporters believe the couple has been unfairly targeted and that invasive speculation crosses ethical lines. Their critics argue that the couple's own actions, commercial deals, interviews, memoirs, invite scrutiny. Both perspectives coexist. But constitutional questions are not resolved by public sympathy. If the Sussexes had chosen a completely private life, relinquishing titles and positions entirely, the conversation about succession might have faded. But as long as titles remain, as long as their children appear in official succession lists, the constitutional dimension remains alive. And that is the heart of the suspense. Not what happened in a delivery room, but what happens if ambiguity persists into the next reign. Imagine a future coronation. Imagine Prince William ascending the throne. Imagine renewed media attention on every branch of the family. If unresolved questions resurface at that moment, they could overshadow the ceremony itself. That is not a scenario any future king would welcome. Some royal insiders have suggested that the palace hoped time would dissolve the controversy. That as the children grow, public focus would shift. But time does not erase legal language. It does not rewrite statutes. The more modern reproductive technology becomes normalized, the more pressure builds to reconcile ancient succession laws with contemporary realities. Other monarchies have faced similar dilemmas. Some have amended laws to clarify eligibility, regardless of method of birth. Others maintain strict definitions. Britain's monarchy, bound by history and international obligations, moves cautiously. For Meghan and Harry, the emotional stakes are equally high. To them, these rumors may feel cruel, invasive, and dehumanizing. They may see demands for proof as violations of dignity. And there is a human argument there. Privacy in childbirth is deeply personal. But constitutional monarchy has never treated royal childbirth as purely private. That contradiction between modern expectations of privacy and ancient expectations of transparency is the pressure point. Public discourse has also been fueled by inconsistencies in narrative details, small discrepancies in timelines, shifts in official language. Again, none of these prove deception. Human memory is imperfect. Administrative communication can be flawed. But when public trust is already strained, even minor inconsistencies are magnified. There's another uncomfortable reality. Social media amplifies doubt at unprecedented speed. What might once have been a fringe whisper now becomes a trending topic within hours. Videos dissecting body language, threads analyzing official statements, side-by-side comparisons of photographs. Whether accurate or speculative, the volume alone creates the impression of controversy. Institutions built in the 18th century were not designed for 21st century digital scrutiny. Prince William's challenge is generational. He must bridge tradition and transparency. He must protect his brother's children from undue harm while safeguarding the crown from structural vulnerability. It is a delicate balance, one that likely requires quiet legal consultation rather than public confrontation. Because here's the unspoken truth. If everything is constitutionally sound, the monarchy benefits from making that known at the appropriate time and in the appropriate format. If adjustments are needed, addressing them proactively is safer than reacting under pressure. The longer ambiguity lingers, the more it invites extreme interpretations. It is also worth noting that public opinion is not monolithic. Many people dismiss these questions entirely. They see them as baseless conspiracy. They argue that the palace would never risk falsifying something so fundamental. That is a powerful counterpoint. But institutions do not rely solely on belief. They rely on documentation. In the end, this story persists because it sits at the intersection of modern identity and ancient law. It is about how a centuries-old system adapts to contemporary life without losing coherence. Harry and Meghan wanted to redefine what it meant to be royal, to step back, to reshape the narrative, to claim autonomy. In many ways, they succeeded. But autonomy does not dissolve constitutional connection. The crown remains tethered to them through lineage. And lineage is not an emotional concept. It is a legal one. If Prince William ever decides that formal clarification is necessary, it will not be personal. It will be institutional. It will be framed not as accusation, but as affirmation. Because the crown cannot function under a cloud. Until then, the suspense remains. The public watches. Commentators speculate. Supporters defend. Critics dissect. And somewhere between Montecito's sunlit privacy and Buckingham Palace's stone corridors, a question quietly lingers in the air. In a monarchy defined by birthright, how much ambiguity can history tolerate? That question is bigger than any one couple, bigger than sibling rivalry, bigger than interviews or memoirs. It goes to the core of what hereditary rule means in a modern democratic world. And until it is resolved, clearly, definitively, and constitutionally, the tension will never fully disappear.